Good afternoon, morning, whenever you're watching this. If you're watching it, like, subscribe, share, comment, ask questions. Happy to answer anything if you put that in there. It is a wonderful day today, and nice to have you here. We're going to be talking a little bit about the situation with Reuters involving Tesla, along with the Sam Altman case involving AI and Elon. Both have some news about that. Before I start about it, we're going to be talking about secrets. Why can't banks keep secrets? Because they have too many tellers. And what spice is the worst at keeping secrets? Only time will tell. Anyway, so I wanted to talk a little bit about first what went on, the basic kind of where we are, the context. So Reuters published an article or a piece yesterday, and they're an electronic publisher, and there's a lot of these out there, and I'm going to get to that in a second. But they cited or quoted or referenced three anonymous sources. And basically, the assertion was that Tesla was not going to go forward with the $25,000 vehicle. Instead, was going to go right to a robotaxi, which is substantially different, doesn't have a steering wheel, etc. It's not approved. It also might take longer for it to come on the market, so it might affect valuation, etc. That's kind of the thought process. After that news came out on Reuters, the stock dropped approximately 5% to about 160 bucks a share. During the day, the price of the stock somewhat stabilized, they picked up some of the losses. I think might have been down about 3% at the end of the day. After hours, Elon announced that the robotaxi that was the subject in part of the Reuters story, and Elon had denied the accuracy of that Reuters story during the day. He announced that the robotaxi would be announced August 8th of 2024, so in a few months. And after that announcement, the stock went back up. So it was, I think, about 171 after hours. So the question is, especially what happens if you happen to be a person who heard the news or saw the news on Reuters, you own Tesla stock, and you sold your stock at, let's say, 160 bucks, and the stock went back up to 171, and you were out and you lost that 11 bucks or a portion of that 11 bucks. Perhaps there wouldn't have been a gain. Perhaps Elon may not have had to come out and talk about the robo-taxi. Perhaps the value would be even greater if he could hold off um, talking about the robo-taxi. So how do we play with all that? I'm going to give you a kind of an example and some suggested alternatives, but I think, just as I've indicated on other with regard to other things, I think Elon and Tesla need to be super aggressive to discourage this type of behavior. To the extent it's not accurate, and that was Elon's position, to the extent that what Reuters said was not accurate, they need to be called out on the mat. They're just publishing information, they're not drafting it. Part of the problem is that these uh, wire, I'm going to call them a wire publications, they don't do much due diligence. They just accept what's provided, and they say there's some disclosure saying they're not guaranteeing the accuracy of the information provided. So it puts the burden of due diligence on you, but they don't really do any due diligence, and I'll get in that in a second. So what can you do? So let's say you sold, or somebody sold, or you want to discourage the practice, but you don't know who's behind it. The allegation was there was three anonymous sources, but they were either employees or connected to Tesla. So if they're employees, or even if they're connected, they probably have a non-disclosure agreement. And by talking to someone, they probably violated that non-disclosure agreement. So that's a problem. So what can you do? So if it was in New York, and I'm sure Reuters has an office in New York, and if you sued them in New York because what they said was false and people have been harmed or the company's been harmed, then even if you don't know those sources prior to filing an action, what you can do, and I'm not a New York lawyer, this is not legal advice, of course, but in New York, you're able, and some other states, but not California, you can file something pre-petition. It's called a pre-petition. And you can ask, after you show that you have a valid claim, you can ask for discovery and for the purpose of identifying who those unnamed defendants are. So you would go into court and say, Reuters, give us the name of those people who gave you that information, who violated their non-disclosure agreement. Reuters would probably say no. You could then go into court pre-filing a complaint, ask the court, based upon your claim, to give you the names. And this would happen before you actually filed the lawsuit. So if you were successful, and that's not a guarantee, of course, if you're successful, then you would get the names, you would then file a lawsuit, etc. So they do, though, and they will assert, now I'm referring to Reuters, they'll assert there's a First Amendment right. They're not obligated to do super due diligence. They are not guaranteeing the accuracy of the information. It's right there. But there are cases where, and I was involved, or I'm familiar with one, I should say, recently, that I would say, just give you an example. So the example I'm going to give you is Fingermotion. That's the name of the company, stock symbol FNGR, Singapore-based company, serves Chinese telecommunications. Offices in New York. So stock, and it seems like it has a pretty decent fundamental setup, not financial advice. So at some point in time, the stock was moving up. There were predictions the stock would really take off. It was over 7. At a significant moment in time, during a potential run, a short, and I'm going to call it a short and distort report, was put out by Capybara Research, and they were located outside the US. It basically called into question various aspects of Fingermotion, but not really in a detailed or specific way, and not really accurately either. But notwithstanding that, because in part, a lot of times what will happen is there'll be algorithms looking for certain content. They see the content that will trigger buying or selling. So what happened is, whereas the stock at that time was over 7, now it's under 3. So a lot of market cap has been lost and investors have lost money. A lawsuit was brought by the company against Capybara. Through that, the identity of the principal was discovered, and also Benzinga, who was a wire, basically, who published these reports without undertaking any due diligence or taking responsibility for the content, were sued. The principal of Capybara was defaulted. In other words, they just didn't participate, and a judgment was obtained. And when I think the judgment proceeding came, there was a gentleman who came, and he was a nut job in the courtroom. But a judgment was entered against Capybara. Benzinga, who was also sued, then agreed to retract entirely the story that they had published. Now, could have a greater remedy been sought against Benzinga, or was it sought against Benzinga? Sure. Could money damages have been sought, or could they have been sought? Sure. There's certain defenses, like I said, because there might be a First Amendment issue. In some states, there might be certain protections for public speech, even if it's inaccurate, but public speech designed to protect the public. So there may be certain defenses, but who's not to say that they could not have sought damages against Benzinga for filing, or for Benzinga in this case, for filing false information and repeatedly filing false information and being a party to a drop in the market cap. So Benzinga agreed to retract it. So what can you do? So now moving to Reuters, if it's established that the information is false, so what can you do? First thing I would do, and again, not legal advice, but one, I'd send a demand letter to Reuters demanding a retraction, an apology, and potentially damages, threatening limit litigation. Now, perhaps that's been done. I would, if I was going to pursue litigation, and I was in New York, and I think Reuters has a location in New York, I would file a petition to ascertain the identities of those 3 individuals. I'd show the claim that there's a violation of the NDA, and to the extent that I need the information because I need to know who the defendants are to serve them and to sue them, there's that petition right. So that's one thing I could do. Another thing I would do if I were Tesla and all of Elon's companies, as they have increased their legal department, I would set up a division that specifically, only addressed false information that was published. And I would jump on any such publications. One, to limit the damage, but two, to inflict a cost so that if someone's going to do it, they're going to spend a lot of money in legal fees no matter what. That's in the best case scenario and that they prevail. So if someone has a First Amendment right and they prevail on that, at least make them spend the legal fees, because all these companies don't want to spend millions of dollars in legal fees there's no benefit. They don't get any remuneration after they spend the fees. That's quite a discouragement. So I would encourage Tesla to have a department that's solely, so if this came out yesterday, they should have been in contact with Reuters with a demand letter. And if Reuters didn't immediately retract, they should have a petition on file and lawsuits on file next week. That's really how it should proceed. But just my particular suggestion. If they don't get satisfaction, so demand letters, they get that filed pre-petition, they have a own department that is interceding, but they don't get satisfaction, they should immediately file a lawsuit. And again, make whoever the violators are or the publishers, because it is the publishers probably that can control the distribution of the information. If they don't publish it, I mean, if Reuters doesn't publish it, then it won't get published. So lawsuits should be really out there to aggressively pursue them to discourage any of this type of nonsense. And last but not least, it should just be a general policy at Tesla, known to the public and known outside and known to employees who have NDAs, that they're going to aggressively pursue everything. And to the extent they find employees who violated NDAs, they should absolutely pursue those employees aggressively. And everyone working there should understand that to the extent that they're operating and have knowledge of proprietary information, that there's a penalty to pay if they violate it. So those are my suggestions as to the Reuters action. I don't know if they will pursue it now because of the announcement by Elon later in the day. But again, I don't think he necessarily would have made that announcement if the Reuters story hadn't come out. Perhaps if it was presented later, there'd be more value to the stock and to the company. I don't know. But no matter what, I think it's got to be aggressively pursued. So that's my first part of it. Second part is the Altman case. So about a month ago, Elon sued Sam Altman and I think Brockman for violation, amongst other things. But the central claim was violation of a founders agreement that they had put together, I think in 2016 or 2017, which basically they were going to work on AGI to compete the models of Google at the time. And that's kind of the summary. Now, I did a live stream with Farzad about a month ago when this came out, and we talked about the contract itself. And I had my concerns about the allegations. At least that's my recollection. I haven't looked back at the live stream to know that for sure. But I was concerned about the specificity of the allegations because it wasn't claimed to be a written contract or oral contract. It was kind of thrown out there. So during our conversation, I recall we discussed that, and I think last week, so today's Saturday, so sometime during the past few days, Sam Altman's counsel filed what is called a demur and a motion to strike. What's interesting is Sam Altman's counsel he's represented by the Wachtell firm that represented Elon at some point in time and sued him for fees, or Tesla. I don't recall if it was Elon or Tesla, but one or the other. So Elon does not like the Wachtell firm. I'm sure in part, although it's a big New York firm, well respected, I'm sure in part the reason why Altman used that firm is because he knew about that and just to piss off Elon. So Elon's counsel filed a demurrer motion to the strike, which is set to be heard April 24th, 2024. A demurrer is a procedural challenge to the sufficiency of the allegations of the complaint. So it's not a substantive argument, generally not a substantive argument, just an argument saying that your complaint is insufficient for various reasons. And part of it is you have obligation when you make a claim to plead. So in your complaint, you have to set forth all the elements of a claim. So if it's a contract claim, you have to allege that there was a contract that's been breached, that the breach was proximately caused by the other side, and that there's been damages, harm, etc. That's basically sum and substance. And for a contract to exist, there has to be offer and acceptance, and the terms have to be sufficiently specified. So Altman's counsel filed a demurrer, and they challenged the contract and how it was pled. And the really basis of the claim brought by Elon relates to the founding agreement. As I had kind of suggested to Farzad, it wasn't very specifically pled, and that's what Altman's counsel kind of focused on, that the founders agreement didn't set forth all the terms, the breach wasn't specifically alleged, etc. So they filed their demurrer motion to the strike. Elon has an opportunity to file the following. So what he could do is he could file prior to that hearing date, April 24th, 2024, he could file a First Amendment complaint. No harm, no downside to doing that. He could look at what the deficiencies that were noted by the Wachtell firm, and in the new complaint, the First Amendment complaint, they could try to deal with that. So that's one way you could deal with it. They might believe that they've adequately set forth enough facts and elements to withstand a demurrer, or they may just want to fight. And if that's the case, then they can file an opposition to the demurrer. That's 9 court days before the 24th, approximately 2 weeks, so about the 10th. So it's coming up. And Altman would have a chance to file a reply brief 5 court days prior to the hearing. There would then be a hearing, or most likely would be a hearing on the 24th. But prior to that hearing, there might be a ruling that was issued by the court. That's called a tentative ruling. It sets forth how the court sees it prior to the oral argument. Absent some, and this is just a general rule, absent some monumental thing that comes up in the oral argument, generally the tentative ruling will end up being the final ruling, no matter what. So it's likely if there's a tentative ruling that will ultimately be the final ruling. It's not etched in stone, but that's generally the way it goes. So either way, on 99% of filings in California, even if the demurrer to the original complaint is sustained, you'll get a chance to file an amended complaint. So if they went forward with the hearing, they would automatically or almost automatically have a chance to amend and clean it up. However, if they file the First Amendment complaint before the hearing date, and then obviously there could be another demurrer to that new First Amendment complaint or an answer. Those are the two choices. And but there would be another hearing. And so even if there was a First Amendment complaint, there was a demurrer after Elon's counsel decided just to go ahead and file a First Amendment complaint prior to April 24th, they probably would have another opportunity to amend. So for me, I probably would file a First Amendment complaint and not deal with the hearing on 424, and then in the future, if necessary, be involved in the hearing. But again, because of strategic reasons of wanting to not back down, or they believe that it's adequately stated, they might fight all the way through. No matter what, there'll be a hearing or not a hearing on the 24th, or we'll know more by the 24th. Either way, I expect that the case will go forward. Either the court will say that enough has been pled, or there'll be another amended complaint, something like that. I don't think the attorneys who drafted the complaint did a super job, in my opinion. I referenced that before. And I hope that they clean it up and make the pleading tight. So at least it has a chance of success. Depending on the outcome, we'll determine the next step, and I'll keep you apprised of what goes on. After that, we'll keep you apprised. Anyway, it'll be an interesting case. It's here in California. I think I told Farzad that if it goes to trial, I'm going to attend the trial. I'll try to attend any significant hearings to keep everybody posted. And have a great day. Be well. Take care. See you soon.